Okay, we are live, Georgiana. I'm so excited to be here with you again. Everyone,
Likewise.
welcome. Everyone, welcome to our Facebook Live. I'm so excited for Georgiana Junco-Kelman to be back by popular demand and joining us again on Facebook Live. As a lawyer, Georgiana has been serving families of kids with disabilities in the Los Angeles area for about 15 years now. However, her journey began as a mother when her own son was diagnosed with a disability and she had to advocate for him. So thanks, Georgiana. Thanks for joining us.
My pleasure. Thanks for having me.
And today we will talk about our rights and the rights of our kids with special needs. And everyone on Facebook, we want to hear from you and we want to hear your questions. We want to hear your comments, and we will do our best to respond during the program. So, Georgiana, here we are. Last time I spoke with you, we were all virtual. Now schools have reopened, but a lot of kids still aren't at school.
Mm-hmm.
And for those kids whose parents have decided to keep them home for many different reasons, they can't seem to access independent study programs, at least not all of them, especially if they have IEPs. So what's going on and what are these kids' legal rights?
It's complicated, but it's simple, right? What I always tell parents first is never forget that despite of whatever, guidelines, mandates, legislation, those guidelines, mandates, and legislations cannot overrule IDEA, which is their child's fundamental right to access a free, appropriate public education. And so the pandemic has been obviously an unprecedented time where different things were done, and we all did the best we could. Not all of us. So what happened? We all came back to school. Distance learning ended for the most part. However, a law was passed by state of California, AB 130 in July, which permitted still distance learning. Independent study became an option for families of children who had underlying conditions or who had a high risk of potentially becoming very ill if they were to contract COVID. Obviously, the variant threw everything for a loop, and kids, all of us, were at a higher rate, still are, of contracting COVID. And so parents were given the option to keep their kids at home under the independent study model per AB 130. However, it's clear if you read the statute that children with disabilities, specifically the ones with severe disabilities, developmental, intellectual disabilities, were not considered when this law was passed. And so parents are now not given any kind of tenable option. Either you keep your kids at home in independent study, and we'll talk about what that means, or you come to school, right? So independent
Let
study.
me stop you right there.
Okay, go ahead.
How is it that they passed a law that basically said, parents, you can decide to keep your kids at home if you feel that they're not going to be safe health-wise at school, but then they didn't make an allowance for kids with disabilities, or at least many kids?
It boggles the
What
mind.
happened?
It absolutely boggles the mind. When I first read it, I literally stopped. I'm like, wait, let me read that again. And I'm looking for, how kids with disabilities are going to be accommodated. The simple answer is they're not, right? They're not. I personally have clients that I am about to file complaints on their behalf, both civil rights and due process complaints, because they've been at home since the beginning of the school year, not accessing an education. These are kids that have a lot of services per their IEP that they require in order to access their education. And so the law, which they're calling it independent study, is just that. Independent study has been around for a long time for various reasons. It was made more robust. It was when it was passed, AB 130 was passed, the independent study mandates or the guidelines were more robust. However, it doesn't apply to kids with disabilities because it doesn't consider the kids that need support in order to access. So when it says independent study, it really means that, and it specifically states it's for kids that are able to independently access online on their own and don't need the level of support. And some kids with disabilities may be able to do that. Many cannot. Children that are identified moderate severe cannot access. Many need one-to-one aids and behavioral support. Many have significant specialized academic instruction, and so they're not able to access that independently.
I have another question for you then. Does this law say that school districts can't come up with another virtual option for the kids who
It does not.
can't study independently?
It does not. but they're telling you that they cannot. So what is happening is we have the law, and then we've got districts applying it differently, right? So different districts have adopted different policies. We can specifically talk about the LAUSD. They've created the City of Angels program. That is their independent study program, right? And so with the independent study law, it doesn't automatically either give a child with a disability the right to independent study. Parents have to convene an IEP meeting as per the law. They have to convene a meeting, and then there has to be a discussion as to whether or not independent study is appropriate, and the team has to offer it. The IEP team has to offer it. And so what are families to do that aren't able to access independently? I just had a very specific IEP meeting 2 weeks ago with a family that were told, you're correct in that independent studies, City of Angels, does not work for your son. Well, their child has underlying conditions, which prevents him from going to school, because parents are not going to now expose their child to the risk of getting COVID and potentially dying. It's that dire. And so this family is home accessing absolutely nothing. And so my argument was, why don't we continue the same program that we've had for the past 13, 14 months, which has worked in collaboration with the RSP teacher, the gen ed teacher, the service providers who are providing services online. And so we asked to carve an exception where we can create that curriculum. And in this situation, as is with many, and parents are choosing to keep their kids home, and they're providing that support at home. And so parents are more than willing to participate and collaborate with the district to create that curriculum at home, and they're applying it and helping the student at home. And so we're not asking for a lot, right? But there's a refusal. No, the policy says this. We cannot go outside the policy, independent study, or
that doesn't help
your option.
kids. Yeah.
And so their hands are tied. It is untenable. And clearly the legislature did not remotely consider these kids, which tells you how far we still have to go, right? In the support of kids with disabilities, because that tells you how marginalized they still are.
Yes. They were marginalized before the pandemic, and then that came along and kind of threw oil on the fire, if you will. And I just want to say that I also have heard these stories from parents, and it's very, very depressing. And also, everyone who's watching, if you have a similar story to share, please do share. We want to hear from you. If you have any questions regarding this, please go ahead and put them in the comments, and we will answer. So what happens next, Georgianna? I mean, what can be done?
Well, right now we are sort of, myself and colleagues that I'm aware of, we're sort of in that, litigation stage, right? We don't have any clear answers. I wish that I could have clear answers for parents. But I would say still call your IEP meeting, attempt to collaborate with the district. I get it. Some families have fear, and it's as simple as that. Their children may be overall healthy, but they're still scared. And the independent study lab permits them to stay at home if they fear the risk. It's a little more specific than that, but I would urge families, if possible, right? If possible, find a way to get your kid to school. Call your IEP meeting, try and put accommodations in place, maybe, further away from the students, make sure they have their mask on, perhaps plexiglass, trying to find a way to minimize that risk. And I know that's a tough road, and some families do not have that option. Their children are too vulnerable, and they cannot go to school because they can't get sick. It's as simple as that. And so those families are left in their lurch. They're left on their own, isolated, without any support. And so their only option is City of Angels. And City of Angels is a cookie cutter, one fits all program. And it's geared for kids that can learn asynchronous, meaning on their own, they're given certain instruction. There's a level of one-on-one instruction. There's a level of instruction with groups. I'm not even sure how it works. Honestly, my family and I have been trying, this family I represent, to really get answers I can't tell you how many emails we have sent to get a clear explanation. How does this work?
I think it's because they're working it out in real time. It's like
they still don't know. That's the
we're
reality.
Still building the plane while we're flying it. I mean, to be fair, and I'm being very charitable here, but to be fair, no one expected the surge and the Delta variant. So when that law passed, they didn't expect as many people to say, not sending my kids back, sorry. Exactly. And City of Angels did not expect to have to completely
Reflects
increase its services exponentially.
absolutely.
So,
When we had this IEP meeting, which was a couple of weeks ago, at that meeting, I specifically asked the administrator, can you explain in detail so the family can understand and make an informed decision what the program looks like? And there were, I think, 13 people in that meeting. Not a one could give me a tangible answer. Well, we don't know. What we do know is what we can't do. What we do know is that we can't keep providing the related services, the speech, the OT that was being provided, which was working perfectly, right? We can't offer that. And so my argument to them was, which I tell parents to at least make the argument, it makes no sense because presumably if the student is at school and the student gets, let's say, 1 hour a week of speech, 30 minutes twice per week, right? That is carved out time that the speech and language pathologist has for that student, specifically the students that receive one-on-one speech, right? So at 2:30 or whatever, 1:30 on a Monday, your calendar says one-on-one with student X, right? So why can't you just log on onto your computer
right,
and provide that service for the student as if they were there with you? The time has been allocated, right? The time is there.
right. Just do it
Why
on a computer.
or find a way where the student can still, even if it's in a group situation, find a way where the student can still have, you can have and it's not ideal, obviously. My point is that there are ways to accommodate these families that can't access because they cannot go to school. The specialized academic instruction is trickier because the RSP support, depending on curriculum based on moderate severe inclusion facilitated, every kid is different. And the point back to the law is that none of that was taken into consideration. And so it isn't fair. It's actually discrimination. It's a violation of the ADA, Title II, to say kids that are typically developing can stay at home safely versus kids.
You're saying it's a violation of the American Disabilities Act.
Absolutely.
Title II.
I have no doubt in my mind. It's absolute discrimination that typical kids can stay at home and learn independently and safely, and kids with disabilities cannot. They are left with absolutely
makes perfect sense.
Zero support. My family that I represent was just told by their school principal, you have two options. Either independent study, in the same breath, he says, which isn't appropriate for your child. We concede that. The IEP already said not appropriate, right? Or come to school, which would then be placing their child in danger.
Child at risk.
And dying, right? Like I said, so you're saying risk death, right? For an education. No parent should be forced to make that choice. And his third option, not an option, the third thing he said, many families are being told this is, well, then we're going to disenroll you from your school. That is what I have in writing.
The last time I checked, I'm not a lawyer, but the last time I checked, the Individuals with Disabilities Education Act guaranteed all students with disabilities a free, appropriate public education that is individualized through their individualized education program, the IEP. So
in their least restrictive environment. And
yes,
at this point, my student's least restrictive environment is home because of his underlying health condition that would submit him to potentially death if he's forced to go to school. And so this family was just told, we are going to disenroll you come Friday if you don't make
that. You have that documented and all of that,
absolutely.
Right?
So I am about to file a civil rights complaint. And it's tricky because, it's between a due process complaint or a civil rights complaint, and depending on the basis of your claim, right? Is it an IDEA claim or is it a civil rights complaint? And sometimes it's both. But in a case like this, sometimes you have to take it to the next level and set a precedent, because this isn't okay. This is a civil rights violation. You're denying a student the right to an education based on at the core, based on their disability.
Right.
Irrefutably. And so we need, some parents, and this family was offered also, the other thing that they're potentially doing, right, is telling parents, well, maybe you can opt for home hospital. But home hospital instruction doesn't apply to this situation, and kids are being denied home hospital because it's a very limited option, and it's for kids who are sick and cannot.
I'd like to hear more about this, because pre-COVID, I actually personally know a couple kids who, pardon me, just had such terrible psychologically damaging experiences at school. They had IEPs that they actually ended up, the mom was able to argue for home
They
hospital.
qualify, absolutely. Mental health is absolutely, if a
Okay,
doctor
so it
says,
can be a
you
thing.
have to hit a doctor's note that says, due to the student's condition, medical, physical, mental, the student cannot physically be in school. And so if a doctor writes that letter and says the student has a permission to stay at home, or that my recommendation is for these reasonings should stay at home, then home hospital applies. But it is for a very specific finite reason. It's for a limited period of time. It's not supposed to be indefinite. And
Right.
so in certain particular cases, students are being encouraged, parents are being encouraged by the district itself. Will apply for home hospital. What home hospital is saying, Carlson is saying no. Student doesn't apply. And so then
So
what do
no
you
one's taking these kids.
Nobody wants
Everyone's
these kids.
passing the buck.
Everyone is passing the buck. In the meantime, these kids are missing an education. And so this
I'm
makes
going to stop
the
you.
next level, which is compensatory education. What can
And
we
we
do?
will get to that next. But we have a comment from, and I really am going to try to get your name right, Agnieszka Kalinovska. I hope I got that right. She's asking, do you know how the district is going to address the gap from lack of proper instruction? Most kids didn't do Zoom effectively because kids on diploma track have to do grade level work, even with an IEP or special ed. And when kids fall behind, they can get frustrated and develop behaviors, and kids are penalized and moved to alternative program or pushed by the assistant principal for parents to agree. So are they doing anything to address the situation?
Well, they're not going to do anything willy-nilly. Parents are going to have to demand, right? So if parents feel that their children have not been receiving an adequate education, they've not been receiving their services. I go back to, where do we start? At an IEP table. You call your IEP meeting and you make it clear. And parents need to understand, and it's a little tricky because parents are being misled. Districts are telling parents that we must show that there was regression in order for the compensatory services to be provided. And that's a very tricky analysis, because you have to do a very in-depth analysis to determine whether a student in fact did or didn't regress. I would venture to tell you that most kids with disabilities regressed. And so, compensatory education, it's an equitable remedy, and it's to remediate the loss of FAPE. And the law, every single federal court has determined that compensatory education isn't something that is contingent on a finding of negligence or fault by the district. So in other words, not receiving your services per your IEP is an automatic violation of FAPE, regardless of why. And the Department of Education, the U.S. Department of Education, has issued very, very clear referendums saying because of the pandemic, we didn't offer services and therefore we're not liable, so we don't have to offer them. Completely false. Completely false. And parents, don't allow your district to tell you, pandemic, we don't have to give you anything. Absolutely not. An analysis has to be done. If a child is not receiving their services, which we can obviously argue, had they received appropriate services, they wouldn't be where they are. So the goal is to compensate for that loss by giving them prospective services, meaning future services for past deficiencies in programming, whether or not it was intentional. The fact that the student had specialized academic instruction, related services, mental health support, and it wasn't provided, that needs to be made up for. And that conversation is had at an IEP meeting. And the bottom line is many districts are telling families, we don't have to. And they stop full stop there. No. You absolutely, you do, and B, my child regress. And there's also the argument of qualitative versus quantitative, right? Some districts want to say, well, we didn't give you 20 hours of speech and language, so here's 20 hours of speech and language. Well, first of all, how are we going to do that? Because the student already is impacted, right, with the programming currently. And so how do you put all this other extra stuff on top, which likely the student does require? But the analysis has to go further than that, because it's not just here's 20 hours. Are those 20 hours sufficient? How do we qualify? How do we quantify the loss? And sometimes you have to really take a closer, very specific look at the student. And it may be that the loss that was suffered is beyond 20 hours of speech and language. So we have to talk about what is equitable in order to match that loss. And it may be the student requires a lot more than whatever it is the student didn't receive.
Right.
And so it's a very, very, very specific case by case that often is being treated the same across all
And
students.
here's another wrinkle. Agnieszka's still with us. Thank you, Agnieszka, for your comments. There is she says, if you have regression, but if you say, oh, my child's regress, then they'll say the kid doesn't belong in the core. They need to go to special ed's self-contained, which is like,
nothing flies more in the face of IDA than being told something like that by your IEP team. And one thing I also want parents to know is do not allow them to push you out of your current setting. If they're telling you, well, if the student is struggling so much because there's been so much regression, the answer is to put the student in a more restricted setting, let's say a special day class, and the student is in a regular education setting. First of all, they can't force you to do that because you are stay put. Anytime the district is suggesting that they want to change your programming, whether it's reducing it or changing placement, they can't just do that. And parents get scared and they're told you have to sign here or your services are going to stop. And absolutely not. Parents always have that control. If you don't agree with that, you simply disagree in your IEP and you're invoking your stay put. And if the district wants to force you out of that classroom or take away certain services, that onus is on them to file a due process complaint against you and prove to a judge at a trial that what they're recommending is appropriate. It's a very long, lengthy process that they typically don't pursue.
I also
I
want to
want
say
parents
one
to know
more
they
thing
have
about
that power. What's
I
that?
also want to add one more thing about compensatory education. I'm not sure if you're aware of this, and I've been kind of ranting about this on Instagram and Facebook all week, that the district is specifically saying, at least LAUSD in particular,
Mhm.
is sorry, I don't know if you can hear that very loud airplane, but the district has been specifically saying, LAUSD has been specifically saying, we don't have to give compensatory education because COVID.
Mhm.
And they've been instructing their personnel. There was an internal training
Mhm.
saying,
Absolutely.
so when parents walk into these meetings, it's like, I've had parents tell me like, oh my God, I was in an IEP meeting for my son last week. And it was like, everybody had a gag order
Mhm.
and everyone was like, no, no comp ed, no, no, no.
Yeah.
So what does a parent do when that happens?
When that happens, first of all, parents should have the knowledge, right? That is incorrect. It's not just incorrect, it's illegal. And so know that and empower yourself with that knowledge and say that is incorrect. And, it's ideal if you can have the law with you and you can show that to them, although it likely won't get you very far. But you have to know that if they're denying it, I go back to the same old, advice that I always give, which is always record your IEP meeting. Always, always, always record your IEP meetings. Go into your meeting, give them notice in writing 24 hours prior to the meeting, and ask very specific questions about your compensatory education and be very clear about your child's regression and your struggles with your child and what was not provided to your child, and ask them their rationale for not providing you compensatory services as a result of that. And so get that evidence on the record and know that you're going to have to proceed to the next level. And some parents can do it on their own. Parents sometimes need to hire attorneys. You can go to the next level in the district, which is informal dispute resolution. And oftentimes they offer you the ability to negotiate at that level and they give you your hours. But don't settle for less than, at the very least, that sort of tit for tat. If your kid didn't get the hour a week of RSP or the hour a week of speech, you are owed that simply at the least. However, like I said, that may not be enough. It may be that those hours are owed, but it may be that your child has regressed so much that current IEP no longer serves your child, and you have to increase services, and you have to look at the goals, and you have to shift and alter the IEP document in order to meet whatever your child's current status is. So it doesn't just stop at, okay, here's some comp ed. Well, no, his current IEP is no longer applicable because my child is struggling more and my child has more needs now.
Exactly.
So report all of that, get that on the record, and you have to file a due process complaint or go to some sort of informal dispute with the district in order to obtain that if
Right.
they're not providing you that.
Right. We have another question from Evelyn Sanchez. What if the child actually excelled during distance learning, thanks to both parents being home and working constantly with him? And now they say the child is doing so well, they want to decrease services.
I go back to the same thing. They can do whatever they want to do in terms of suggesting any kind of altering of the IEP. They cannot. You simply disagree. And I always say have a collaboration is key first and foremost, and so just reasonable minds tend to prevail, and parents can have the argument of, listen, we just cut back, right? My child did okay because we went above and beyond what any parent should have to do, and a lot of parents went out of pocket. So if you went out of pocket, that tells me that they owe you something, right? That what you accomplish is because it went outside faith, free, appropriate, free, public, meaning you shouldn't have to pay for anything. So if you had to pay for things, it's because the district didn't provide properly. But have that conversation. Let's give it some time. Let's not be unreasonable. It may be the student is doing so fabulous, they may not need that service, right? Why are we pulling the kid out of the class if he doesn't need it? Great, but it's too soon. The school year just started. We're a month in, and it's way too soon to take away anything. Let's give it some time, and let's come back in December. Let's meet in December for another IEP meeting. Let's take a closer look. And if my kid's thriving and doing great, good on everybody. Let's agree maybe at that time to reduce some services if we feel it's warranted, and perhaps assessments are done, more data is collected. But have that discussion. No, I don't disagree with you. Perhaps my child may not need that in the long term, but right now it's too soon. Let's come back in 2 months. So just
Thank you, Georgianna.
a sort of negotiation of, let's not say we're not going to, but let's give it a little more time. Let's come back in a month to see how he's doing then. And again, even then, the parents hold the power. If you don't agree, stay put. And if you want to take it away, go prove it to a judge. It's as simple as that.
It is. It really is simple.
It really is. In
it's
fact,
what the law guarantees your child. We have more questions.
Their signature page on the Well-Agent a few years ago. Remember the way that Well-Agent was written, the way this signature page was written, it made
Well-Agent is a system used in LAUSD. I'm just going to point that out to those who are not.
The IEP document. It's the system that's used for the LAUSD. But for some time, it was very confusing because the way that document was created, it led parents to believe that the onus was on them if they disagreed to go to due process. No, and parents are doing it all the time. You don't have to do a thing. You are stay put. Your services are protected. If they want to take something away, that onus is on them to do it. And so
they can take it away if you don't sign it.
Exactly. And you saw a decrease in due process complaints after that form was changed because parents always felt compelled to automatically file.
They're like, oh, I have to go to due process now. Okay. We have more questions. Before I go to the next question, I'm going to go, hola, Perla. I see your comment. She's like, hey, special ed warrior mom. And Evelyn Romero, I know also another warrior. She says, my daughter is 4 and her teacher just suggested to transfer my daughter into a different program, but she will lose her ABA, and explain to her that her doctor wants her to have more ABA.
Well, I go back to, you should never have to give anything up that your child needs in order to get something else. Both things are needed. It may be she needs a different program, but she may still require her ABA support.
Right.
And so it's as simple as that. And in a situation like that, if the district is telling you, we do think we should move your child, and you agree with that, let's say you want the different placement, but you still believe the child requires ABA, then maybe that might be on the parent to file, right? Because you do want to change placement. You don't want to stay where you are, but you believe your services should go with you. And so if the district is disagreeing on that and refusing, because, stay put. If they're refusing to allow the change in placement, then that is when you will have to go to due process potentially to argue for the placement and the services.
And doesn't the I in IEP stand for individualized?
Individualized. And I can't tell you how many times I start IEP meetings by saying that, because they operate the same cookie cutter programs, especially transition from elementary to middle school. It's always the same thing. And I always go back to individualized. How is that individualized? A cookie cutter program doesn't apply to every child. This is the very, core crux of IDEA. And, oftentimes what happens to their, to not completely point fingers, there isn't sufficient training. There isn't sufficient education for administrators and teachers. Most teachers, general ed teachers especially, that I talk to, don't have a clue. Not one clue what they require.
That's a big axe to grind. I have that. Mm-hmm. So many teachers are coming to the classroom and they're not well prepared, and they're like, I don't know what to do with these kids.
And now that we have,
it's not their fault that they don't know.
It's not their fault, and I have to remind myself of that. And in this day and age, we have 1 in 5 children diagnosed with some kind of learning disability.
Right.
And so, in my opinion, I think that regular education teachers should be required to have some level of special education training. That should be a requirement. And there is some level, but minimal, in my opinion, and negligible in some instances, where teachers need to be educated and trained properly to support the needs of all the kids in their general education classroom. And not think that because the kid has an aide or an RSP teacher that it's up to them to provide. No, it's a collaboration where the gen ed teacher should be a central core role in this. And oftentimes they're not, and they're sort of isolated because they don't really know what to do. And they leave it up to service providers, and the child ends up being in the classroom parallel and not really meaningfully participating.
And that doesn't work. I also remember having a conversation with you recently where you said that there was also a shortage of providers.
Ugh.
We all know there's a shortage of providers and special education teachers. We know this, right? And for all of you guys who didn't get the memo, there's been articles in the news about it. It's a real thing. But that now non-public agencies are short on providers. Is that right?
Absolutely. It's, the mandate with the vaccine. Many service providers don't want to get vaccinated. And so obviously, if you're an employee of the district, you don't have an option. Either you get vaccinated or you're going to get fired. And non-public agencies that are contracted with the district cannot order, obviously, those employees of agencies to get vaccinated, but the district can say, I'm not going to allow, your employee to come service the child in our school. I right now have 2 cases that the district agreed, the BID, the behavior intervention and supervisory support in the classroom for both students, and through non-public agencies, so privately contracted with an outside agency, because the district itself doesn't have aides. So
Right.
The agencies that I'm reaching out to try and facilitate and expedite the process are telling me, we don't have behavior interventionists to offer you because we don't have enough people that want to get vaccinated. And so there's a huge shortage now where the district, IEPs are being violated left and right because the districts can't hire aides for one reason or another, whether it's vaccinations or what have you. There's such a shortage of even district aides. And, the non-public agencies were, the go-to. And now we're being told we can't hire anyone to save our lives because people don't, A, want to work, and B, are not wanting to get vaccinated. And so if you're not vaccinated, you can't go into public campuses, specifically the LAUSD. And you have these kiddos now that don't have proper behavior intervention support, and teachers are pulling their hairs out because these are kids in general education, regular settings, without the support they need in order to be in that setting. And so what's going to happen? We're going to then propose that they be in a more restrictive, smaller setting where they shouldn't be, but for having the proper support. So it's a grim time. It really is a grim, scary time for many families.
And we have a comment in the chat from Patrick Bromark saying, oh my God, this is so true. I had an IEP last week. This is going back to everyone having a gag order on offering compensatory education. And they all had a gag on the pandemic. They did not mention that word. We had to express the academics and social emotional situation during the meeting, which is...
I'm often accused of being a little too forward and opinionated. And
you makes you a good lawyer, though, don't you think?
I am, first and foremost, an advocate for these kids, and I do not mince words, and I know what is happening, and I will often point fingers, although it's not, proper protocol or whatever. You have to get in these people's faces and say, no, this is a kid whose entire life is on the line, right? Because if we're not going to educate them now and give them the tools that they need, these kids are going to be miserable failures in life. What happens too is these kids become, absolutely emotionally devolved. I had a client today who is telling his mom, I am stupid. I want to die. I can't learn. And this kid can learn. He has dyslexia, but he's not being taught the way he should be taught because the district programming is a miserable failure. Most of them are for dyslexia. And so when you go to these meetings, especially after the pandemic, kids that have significant reading impairments have fallen so behind. And so you've got to raise your voice and you got to demand more and you got to go to the next appellate level with or without a lawyer. I would highly recommend you get a lawyer. And I hate to have to say that to families because I know there's so many families that are just like, we can't afford an attorney. We can't do this. Go to a lawyer, find a way. Many of us will take on your cases. When you go to due process, we don't have to charge you. don't be scared to pick up the
There are
phone and
many
ask
good
for help.
lawyers who they
So
charge the
many of us.
district. Yeah.
Absolutely.
And don't charge families.
The districts, the IDEA permits reimbursement for a prevailing.
Unless you do ADR.
Right. You can do ADR, and I can tell you that I'm helping out a lot of families because these are exceptional times. And if you call me, I'm not going to turn you away. I mean, I'm doing whatever I can to help these families, and many of us are. I don't consider other attorneys that do what I do my competitors. I consider them my colleagues because there's not enough of us to go around,
right?
To help these families. There's such a need, and 90% of families don't get help. 90% of families accept what they're given, and their children end up graduating from high school at second grade reading levels, and especially after the pandemic, demand those comp ed services. And if the district isn't providing you an appropriate placement, I want families to know that districts fund private placement. Districts fund non-public schools. If you're at a point where you've tried it all, then you fight for that and find a lawyer that's willing to fight for that, because it is entirely possible. There's always, and I know it's so grim and difficult and hard and frustrating and exasperating. I get it. But it's a fight that parents can't afford not to engage in whatever way they can figure out.
Bottom line. We have a comment from Michelle Jewell. I feel so bad for the parents that never knew what the school could offer. My child is 10, ADHD, on IEP, and he never knew he could be assessed for an occupation. Oh, I never knew he could be assessed for an occupational therapist. Now I'm asking, and now I'm thinking about all the treatment he could have had.
Mm-hmm.
And Michelle, I'm with you. I had a situation where I didn't know about recreational therapy until it was too late. Until years later, it's like not really applicable for an older kid. And it's frustrating. It's frustrating not to know when you need to know it.
Especially when we know that there's so much available, right? We know how much support legally is available to students. But the system is stacked against parents. And I'm often criticized for speaking this way. But I say it because I know for 100% certainty that it is true, because I've been in this system for 19 years and I've seen it firsthand repeatedly. And, my colleagues in my practices grow exponentially every year because the need continues to grow. And while we've seen progress, we are still seeing such a tremendous deficiency in providing appropriate, sufficient services for kids. And families have no way of knowing about these additional therapies that can make such a difference. And so at this IEP meetings, at least ask, what else? My kid has this other need over here. What can we do to meet this other need? Because what parents don't know is providing an IEP and services isn't just academics. It's social. It's emotional.
It's the whole child.
The ability to communicate, to participate. Not just the academic raw component of an education. It's having the ability to communicate, to raise your hand and ask a question, hence language and speech therapy for kids that can't communicate or have pragmatic language issues. And oftentimes they're given the bottom of the barrel, or they're not told at all that their child requires additional services. And I get how frustrating that is. I get that, as a parent, you feel like a failure when your child is 13 and you realize, oh my God, you mean I could have done all these things and no one told me? But how would a parent know that? Because the way the system is set up, they are not told. And I cannot tell you how many teachers call my office anonymously or send parents to me and say, call Georgianna, don't tell them I sent you, which I always figure out who sent who. And I commend those teachers because they're afraid to speak up and tell parents at the very least, you know what, we've done all we can, go get a lawyer. Or what I tell teachers is, you know what, your job is to teach all students and to serve all students, typical and disabled. And as a teacher, your duty is to go to your administrator and say, this kid needs more help. And you shouldn't get in trouble for that. Teachers shouldn't be afraid to speak up on behalf of
They do. I mean, I've heard of principals saying, don't refer any kids for IEPs, don't refer any kids for evaluations.
It is pervasive. I had a client call me yesterday from a teacher who I love this woman. God, I'm so happy that she did this. She's an RSP teacher at a particular school, and she's been watching what's been happening for 2 months. She called the parent on a Sunday night and said, in good conscience, I could not any longer sit back and watch what is happening. Your child has not received any support. They're going to offer you X, Y, and Z. It's been predetermined. Don't accept it.
Teacher of the year.
Absolutely. But the thing is, teachers have their glorious union behind them, right? They're there to protect you. And if you speak up on behalf of a child and your administrator retaliates you or slaps your hand, call your union rep. File an action against that administrator. That is your right. That is why they're there, to protect you. We all know they've been screaming bloody murder for the past 18 months. So you know what? How about you use that union to protect children with disabilities as well? You absolutely have the right to do.
I'm behind that.
But I
We
don't
have a question from Liz. With the update on the AB 130, does that mean kids can now go virtual without signing the settlement agreement?
What do you mean without signing? It shouldn't be. I mean, you can go to due
Liz,
process.
can you type in the chat? What do you mean by the settlement agreement?
It's not offered via settlement agreement. Independent studies offered at the IEP if deemed appropriate.
I wonder if Liz went through alternative dispute resolution.
And Liz, do not, this is to all parents, blindly sign settlement agreements that will allow you to participate in independent study, whatever they're telling you. It may be for the past 2 years, you've got all kinds of claims. And you shouldn't give up those claims. When you sign a settlement agreement, especially if you're unrepresented, I will never do this. Obviously, we're attorneys. When parents are not represented and the district says, sign here in order for you to get this, oftentimes parents don't read that very critical paragraph that says you are giving up all past claims, any violations the district may have engaged in for the past 2 years, you are waiving that in exchange for independent study. Independent study is something that should absolutely be provided. I tell you, most kids, not most, many kids with disabilities don't benefit from it, but some do. And the ones that may be able to, the IEP team should offer it based on appropriateness, and they shouldn't tell you, let's give you independent study via ADR. Absolutely not.
And another thing I've heard about ADR and what it means is alternative dispute resolution is that basically families who can afford a lawyer and not get reimbursed by the district, they'll be fine.
Mm-hmm.
But ADR is all about not having lawyers involved and having that money go to the kids. But honestly, I'm pretty knowledgeable compared to the average parent about special ed. But if I had to go to due process, I would, or if I had a real dispute with my kid's school, you can be sure I'd want to have a lawyer with me and have those fees reimbursed, because lawyers would be expensive for me, because I know that the district has so much legal counsel just embedded. I mean, everybody at that table from the district has lawyers on their side. That
agreement that you're signing was reviewed by their lawyer.
Exactly.
Who's reviewing that?
I would just be reading it like, I don't know.
Who is reviewing the supposed terms that benefit you? Right. No one is reviewing those terms. That agreement is written, skewed in a way that protects the district. And I get so upset because it is so unfair when clients come to me, they've agreed to something, they've waived everything, and a month in, it's a failure. It doesn't work, and they want more, and they've waived everything in writing. Sometimes, prospectively, depends.
Liz followed up, and she said, she meant my daughter's school won't let her go virtual unless I sign release of claims.
Those are the things that give me headaches. That's absolutely illegal. Absolutely illegal. Call your IEP meeting again, go back, tell them you're recording it. Tell them that you believe that independent study is appropriate for your daughter. Ask them to articulate why they don't think it's appropriate and put it on the record. Why are you asking me to give up my rights and sign off anything else that I might want to pursue, right? Because you may have other issues that you want to resolve. But they should never make you sign a settlement agreement to provide you that which should be offered via FAPE in the IEP. Independent study is an absolutely feasible, again, not for many kids, but it can work for some kids with disabilities. And they should not make you sign a settlement agreement in order to receive this. That should be your offer of FAPE in your IEP. And there's no reason for them to force you to sign a settlement agreement when this is what you are entitled to, like any other typical family. They're all given the option of independent study. And if your child is in an underlying condition, if you fear the virus for any reasonable cause, whatever it may be, AB 130 permits you to keep your child at home, just like any family of typical children. And you should absolutely demand that, and don't let them bully you into a settlement agreement. And go get a lawyer. Go get a lawyer.
Liz says she had a lawyer that still wanted to sign, so I think you have to take it to the next step, Liz, because That is just not right. Okay, we have one more question. It's a little bit of a different kind of question. I wonder if you can feel it, Georgiana. And I'm asking it also because it's something I've wondered. It's if you file for PSA, if you homeschool your child and pull your child out of the school district, is a school district still responsible to provide services?
That's a little complicated. So there's no law in California that allows homeschooling. So that is a district by district decision. You have to typically apply with the superintendent's office or with the superintendent. You know, every district is different, but you've got to apply for homeschooling. And if it's granted, you're going to homeschool is like going to a private school. So you are opting out of your IEP. Now, can you still file a due process complaint and argue that you want, X, Y, and Z that you didn't receive, and so you left the district and opted for homeschooling, which that placement now becomes a sort of private placement. The student's new educational placement is home, so that's considered their schooling, but that doesn't prevent families from still disagreeing with FAPE and pursuing some kind of level of compensation, even if they're homeschooling. But if you're just opting to homeschool, because you just, for whatever reason, feel safer and not because the district isn't offering you something, let's say, which is very rare. But if that's why you just opted, I just want to homeschool my kid for no other reason other than I want to, then that's a little more complicated because then you are opting out of special education and your IEP no longer applies. You get what's called equitable services.
One workaround, though, I've seen, and whether you love them or hate them, online charters, I know that they have to, because they're public,
They're still liable.
They have to offer you services if there's an IEP.
Right. There's a number of online virtual academies who are public,
right,
and they absolutely still have to apply your IEP and still have to provide you. It doesn't have to be exactly the same way as your previous IEP. They'll hold a 30-day, like anywhere else. When you transfer from one district to the next, they have to convene a 30-day IEP meeting and review past IEP and with either apply it similarly, or they can then suggest how they feel they can meet your students' needs and come up with a new IEP or what have you. But they are still responsible. That's always a way out for parents. If you do want to homeschool, meaning you want your child at home, you can opt for a virtual academy that could help you navigate that educational process. So your child is being taught by someone else, not by you, which is what homeschool is the parent's own curriculum is being applied.
Okay, we're coming up on time, but I'm going to do one last question that popped up. And it's Mali Alcantar. I requested my school record all any from the 3 years they've come from the special ed department. And the only copy, I think the cumulative file, and the only copy I've received has 45 pages with none of the IEP from the past 3 years in it. So I will go for due process. I need those pages. So what do I do?
Well, the educational code requires a district to provide you with your special education records within 5 days of your request, within 5 business days. That is not something they can deny you. And so make sure you put it in writing. The LAUSD will tell you, you go to your assistant principal, your principal, and say, I'm going to make a request of records of my special education records. And the LAUSD specifically will tell you, okay, well, here's a form for the custodian of records, blah, 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 which I always argue against because all you have to do, all the code requires you to do is put in writing or orally. The code specifically says either oral or in writing, communicate, I want my educational records. Be very specific about what you want. I typically request the entire cumulative file, anything that identifies the student educationally and specifically special education records, which means assessments, IEPs. They have to give you all of that within 5 business days of your request. That is not something they have the right to say no to.
That isn't state law.
Simple thing. It's state law.
I had to use that once. Yeah.
If the LAUSD tells you, call our custodian of records, that's delaying your request unreasonably. And so I always argue, here's my request. It's in writing. In 5 days, I expect it. I typically get it. Parents,
okay. There's one more question, and I can't turn it away. I know I said the last question was my last question. This will be the last question. If any more come in the chat, I will be responding. And also, everyone, we're doing this again in Espanol at 5:30. So for those of you who speak Spanish, you can come again at 5:30 at Latinos Padres Unidos on Facebook. But Patty Villalobos says, my son's IEP was closed once he was going into kindergarten. They claimed his evaluations at the time showed no need. I see him struggling so much. What can I do? I'm asking for help and nothing.
Again, first of all, don't ever allow them to tell you we're closing an IEP. Don't ever allow them to tell you anything that takes anything away or changes anything meaningfully that you don't agree with. You are stay put. Before they can take your IEP away, they have to do assessments that show a clear recommendation that the student no longer has X, Y, and Z need. Even if they do that, you can still say, I disagree. And I'm going to invoke stay put, which means whatever the IEP is offering your child has to continue. Back to the district has to file a due process complaint, prove to a judge that the student no longer needs an IEP. Now, if you did agree, the short of it is get a lawyer. But if you did agree and you signed to exit your child and you're still seeing need and go to your teacher and again try to collaborate, try to get your teacher as your ally and have your teacher say, yeah, kid is still struggling, he needs X, Y, and Z. Go to the administrator of the school and put it in writing. My child continues to suffer and academically not accessing because of his disability. I believe child fine, which is the law that says that the districts have a responsibility to locate, identify, and assess students with disabilities. It's federal law. It's a very low threshold. All you have to do is show that there's a likelihood, not a likelihood. It's like I said, low threshold, that there's a possibility that your student has a disability that is impacting learning. That is all you have to show, not that he actually has one. That is enough. And if you've got data that shows he's struggling, that is enough to put the district on the hook to assess again. So go back in writing and say, my child is struggling. I believe he still needs an IEP. Please provide me with an assessment plan to assess my child within 15 days of today's date. They've got to give you an assessment plan. You sign in consent. They then have 60 days to complete this assessment, convene an IEP meeting, and you determine eligibility, placement, and services. Again, that's the short of it. Do that. Put it in writing, or nutshell, go get a lawyer.
Thank you, Georgiana.
My pleasure.
I wish
forever. I could go on for.
I feel the same. I could talk forever, and I wish there were nothing left to talk about. I wish that this could all be resolved. But the one thing I think we can all do as parents is inform ourselves, keep on fighting, find your squad, find your community to lift you up when you get frustrated, and just keep at it. And I hope to see all of the Spanish speakers in 9 minutes at Latinos Padres Unidos, the Facebook page, Latinos Padres Unidos. Georgiana and I will be there conversando en español. We'll be talking again about special ed. So thank you all, and we'll see you soon.
Okay, bye, everybody.
Bye.